Let's start talking about trade dress. Trade dress is, the product's total image, the way it is presented in the marketplace. And trade dress basically has two forms that are of interest to us. Things like product packaging, so, a can of soda, the box in which the Tylenol bottle comes in, and apparently a restaurant layout, as you will see when we discuss the Two Pesos opinion. Or we can talk about product design, which will be the subject of the next lecture. Things like, the clothing, or a designer handbag, or the configuration of a knife, or this mouse that I'm holding right now and using to keep track of my notes in this presentation. So anyway, the first important Supreme Court case in current precedent line concerning trade dress is Two Pesos versus Taco Cabana, a case from 1992. And, the trade dress of Taco Cabana, the plaintiff, is a festive interior and patio design, artifacts, bright colors, paintings, murals, vivid outside colors, awnings, and umbrellas. And what does Two Pesos do? They open a similarly themed restaurant. And, you look at this list and you can see any number of things that, by themselves certainly shouldn't be the basis of trademark protection. I think it's an open question whether the combination can be protected or ought to be protected under trademark law. Whether it can be is a subtle question given the way the Taco Cabana case came out. And one thing that may be interesting, or was interesting to me when I see this list, is that I don't see any claim of any specific colors. And you may wonder, well, why not? Why isn't Taco Cabana claiming the specific color scheme of, say, its particular restaurants? And when you actually look at the restaurants themselves, you see why. That Taco Cabana has a different pinkish color, or I don't know, it's hard to tell exactly from this photo in the exhibits, compared to the blue one of Two Pesos. And so, of course, if they had specifically claimed, like, oh, this is our particular color, it would have been much harder to credibly entertain a trademark infringement suit here. And you can see some of these problems in the actual findings from the jury. The jury concludes that Taco Cabana has a non-functional, distinctive trade dress. But even though it has a distinctive trade dress, it does not, in fact, have secondary meaning in the marketplace. So it is a distinctive trade dress. Consumers are automatically predisposed to seeing it as performing a trademark function in much the same way we are predisposed to see Apple, when attached to computer, as performing a trademark function. Nonetheless, there is no, in fact, secondary meaning. Consumers do not actually see it as performing a trademark function. Nonetheless, the fact that Two Pesos is using a similar trade dress creates a likelihood of confusion. So the jury findings are kind of at war with each other. And, this is a fact of life in the law, of course. Sometimes you have fact findings that are by the juries that don't look necessarily consistent. But note that there's something, really at odds here, right? No secondary meaning, but it's inherently distinctive and it's likely to confuse. And it at least raises the question whether or not the jury understood what it was being asked with respect to the meaning of distinctive. Is it distinctive in the trademark sense, that it actually identifies and distinguishes a product in the marketplace? Or is it distinctive in the sort of the lay sense, like, yeah, I see that, that's a distinctive thing, or like, oh, that's a look, or that's a something? I think it's an interesting question to ask whether or not these are the kinds of determinations that fact finders are well positioned to make in the trade dress context. And this is an especially important question given the potential scope of trade dress rights once they are granted. The issue for the Supreme Court is whether or not secondary meaning ought to be required in the context of trade dress. And the Supreme Court says quite clearly, nope, inherently distinctive trade dress can be a thing. And so why can it be a thing? Well, first of all, we don't see anything in the Lanham Act that suggests that it isn't a thing, that there's nothing in the statute that says that we should be treating trade dress differently than trademark. And this actually gives rise to a very interesting debate that is joined in the concurrences of the opinion between Justices Thomas and Stevens, where Justice Stevens basically points out that, look, Under the language of the Lanham Act as it existed at the time of this litigation, there is no way that it could be stretched to cover the kind of trade dress at issue here. That just didn't seem to be the kind of thing that could be protected under trademark law as it existed prior to its amendment. However, by the time this case was heard, the Lanham Act had been amended in a way that made it clear that you could protect things like trade dress. The language became a good deal more capacious. And so this case kind of arises at an awkward transition point. And Justice Thomas, purporting to be a textualist, has to kind of engage in certain, I'm going to be a little, disclose my bias here, engage in some contortions to try to claim that no, this is the kind of thing that is justified by the statute. But the point is that we have an actual debate about whether or not the old statute should have covered this case in the first place. That's really not as much of an issue with the new statute. But in any case, the court says, since we assume that this is the kind of thing that can be protected under the Lanham Act, we don't see any reason that it should be given a different standard than a word mark. In addition, to the extent that we might be afraid that somebody might claim a trade dress that is functional, well, we can still we can handle that with the functionality doctrine, the principle that functional trademarks cannot receive protection. So we see once again this sort of hydraulic effect within the law, that we let in something on the front end here, but we're assuming that another doctrine is going to be capable of handling the potential fallout if we allow trademark protection for trade dresses. It's worth thinking a little bit about some of the trade-offs of this decision. So think about an interior of a restaurant, or say a coffee shop, and think about like certain standard parts of a coffee shop design, and since it's the most prominent brand, let's think about the interior of a Starbucks. And so when you walk into a Starbucks, you see a distinctive look. Distinctive in the layperson sense, right? Starbucks has a certain uniformity of design from shop to shop to shop. And so do you think that that look is performing a useful trademark function once you are actually in the door, or that you're actually getting information beyond what you get from the big Starbucks coffee that is there on the window or what have you when you're walking in? Answering this question, or having a sense of your answer to this question, is part of whether or not this game is worth the candle, whether or not there's actual trademark work being done, and whether or not there might be some danger on the back end of locking up utilitarian features that maybe ought to be subject to competition in the marketplace. Because why do people go to Starbucks, or why do people go to their favorite coffee shop? Sure, they may be in the mood for coffee, but maybe if with respect to Starbucks, if it's a coffee shop near you and you don't necessarily like their burnt flavored coffee, you may still go in and do some work, right? Because why? Maybe you like the layout of the store, you like the cozy seats, you like the artwork, you like the wood tables, you like the tasteful, non-threatening jazz playlist curated by Jewel or whatever. And this stuff may actually be part of the Starbucks experience, but it's not necessarily something that Starbucks should be able to claim in the marketplace, insofar as those features might be something that others might want to offer customers. And so we get into this tricky question about how much can trademark law interfere with the subjects of competitive offerings, the kinds of things that various entities may compete in. And then we have the administrative cost question about whether or not juries can understand what we mean when we say distinctiveness as a source identifier, something that identifies and distinguishes a good or service from others in the marketplace, versus something that is distinctive in the sense of, that's a thing, that's a look, that's a distinct reason I have for going to Starbucks, rather than the thing that lets me tell that Starbucks is distinct from some other coffee shop. And it's possible, perhaps, that requiring secondary meaning would ameliorate some of this. You could point juries to what is the question, right? Is this actually performing a trademark function? And hopefully you properly instruct juries on what that means. And then, we have this question of error costs. What happens if juries deem a standard feature of a restaurant genre to be protected trade dress? And again, non-functionality may address that, but you're assuming that the functionality doctrine, which we're going to cover in future lectures, actually is adequate to the task. And then we have a problem of feedback. As you have litigation on this kind of thing, as the Taco Cabanas of the world litigate against entities with similar designs and restaurant decors, you have people being afraid to kind of get close to the line. And so the scope of the Taco Cabana trade dress may be more than the precise trade dress itself, that the scope in practice may be broader. So another question we have, and I think it's an important one, and the court doesn't really grapple with it, is how much source identifying trade dress is out there. And it's not just a question of how accurate a court may be in answering that question. I think it's important to know what is the actual base rate of source identifying trade dress that is out there, because that will affect how many false positives or negatives we might get under whatever distinctiveness analysis a court chooses. So imagine you have an expensive medical test, and let's imagine that this medical test is 100% accurate with respect to false negatives. So nobody who has the disease is going to test negative, but with respect to false positives, it's 99% accurate. So only 1% of people who don't have the disease are going to test as being positive. Is this a worthwhile test? It sounds pretty good. 100% accurate on false negatives, 99% accurate on false positives. Sounds like a good deal. But do we actually know it's a good deal? We're missing one critical piece of information. We need to know how much disease is out there, how prevalent this disease is in the population. Because if nobody has the disease and you were to test this 99% accurate on false positive tests on 100 people, you're going to get a false positive without catching anyone who actually has the disease, because no one in the population actually has the disease in the first place. And now magnify that out into, say, a population of 100 million people. Now you've got 1 million people coming up with a false positive when they don't actually have the disease and the test is expensive. Of course, if you have a situation where the disease is quite prevalent in the population, then it becomes worthwhile to have this kind of test. And so with respect to trade dress, you have to have some kind of prior about how much source identifying trade dress is out there. If you think there's actually not that much, then the result of not requiring secondary meaning starts to look a lot more suspicious, or starts to look a lot more problematic, because you have the potential costs of how trademarks may be used in practice, with the fact that a lot of the trademarks that are going to be granted aren't actually performing a trademark function in the first place. Another interesting question raised by the Taco Cabana case is this question of how exactly should the court go about resolving these questions. And so, I'm just throwing out some sort of policy arguments in this regard. And you may think that that's not an appropriate way for courts to address certain kinds of contested questions. And so maybe this should be just a question of pure textualism. What exactly does the Lanham Act say? And so, here that's actually a trickier question than the court makes it seem. And that's the subject of, again, what I mentioned before, the Stevens-Thomas debate in the concurrences. How else might we try to decide a question like this? Well, one possibility is that we look to the fact that the Lanham Act was a statute written in the 1940s, and it comes on the scene after a long tradition of a common law of unfair competition. And the common law actually had some rules in this regard. And the common law actually would have required secondary meaning to protect a trade dress as a trade name under the law of unfair competition. And the usual understanding in statutory interpretation is that if Congress is writing against a common law backdrop, where there are certain settled understandings, and Congress doesn't explicitly override those understandings ought to prevail. And as we'll see, the Lanham Act is really an incomplete codification of trademark law. And so a possible answer is that the court should have been a little bit more open or willing to consider what practice had been prior to the passage of the Lanham Act in the first place. Because a lot of the policy questions that that people have identified with protecting trade dress were simply addressed at the front end by making it harder for trade dress to get protection. Or we might look to something like congressional intent. So even though at the time of the facts giving rise to this litigation, the Lanham Act was not really open to protection of unregistered trade dress, Congress kind of gave its blessing in the meantime by amending the statute in such a way that this sort of claim was possible. Query whether that's something that should resolve matters of congressional intent. And interestingly, in the Stevens concurrence that I referred to earlier, Stevens sort of says, the language as it was not willing to accept this stuff at all. But you know what? It's actually a good idea to allow this kind of to allow this kind of claim, and Congress gave its blessing, and so I'm cool with that. And of course, Justice Thomas, who sets himself up on the textual side of these kinds of interpretation debates, says no, this really is in the text, and he kind of has a hard time stomaching the idea that we're just doing stuff because Congress intended it to be so, or that it's a good idea from a policy perspective. And of course, that's the final possibility, that we look at this as a question of policy. And note that it's not just a question of substantive policy, a question of what kinds of things ought to be marks, what kinds of marks might take away from competition. It's also a question of judicial/administrative policy. What kinds of frameworks are going to be easier for fact finders, the courts, or the Patent and Trademark Office to implement in practice, and which kinds of approaches are going to be more prone to error costs or the like. And so these are issues that recur throughout trademark law, and this question about how are you going to fill various gaps in the Lanham Act. And so they're really quite fascinating, and we will see them again and again over the course of these lectures. Thanks very much.